Thank you all so much for being here. My name is Isa Peña, and I'm the Director of Strategy at Innovation Law Lab. Thanks so much for joining us today after our Clear Clinic v. Nome hearing. Today's speakers are Tess Helgren, Director of Legal Advocacy, Kelsey Provo, Associate Legal Director, Nelly Garcia Orjuela, Staff Attorney, and our plaintiffs. Marlena Campos, Organizing Director at Pecun, Lainey Tupper, Executive Director at Clear Clinic, Katrina Kalgren, Immigration Attorney, and Josephine Moberg, Staff Attorney at Clear Clinic. We will be posting the names in the chat so that you all have who will give us a quick rundown about what happened today. Then later, the plaintiffs will share about their experiences, and then we will open it up for questions. We'll take English questions first, and then if there are any Spanish questions, we can take those after. You all can also type your questions in the chat or raise your hand to be called on. Any questions before we get started? If not, I will pass it to Tess. Thank you.
Thank you, Isa, and thank you everyone for your interest and coverage on this case. So today was an evidentiary hearing on plaintiff's motion for a preliminary injunction in the Clear Clinic v. Nome case. This is the lawsuit challenging ICE, CBP, and DHS over the systematic denial of access to counsel at ICE facilities in Oregon. And in this case, Innovation Law Lab is privileged to be counsel on behalf of the attorneys at Clear Clinic, the organization and members of Pecun, and individual plaintiff Leon X, who is proceeding under pseudonym and seeking to represent a class of similarly situated Oregon community members at risk of immigration detention. So this case, which was first filed in October, is a case about access to counsel. What plaintiffs are requesting is the meaningful enforcement of the constitutional right to counsel for individuals who are subject to civil immigration arrests and detained at the Oregon field offices. In recent months, defendants have exponentially increased immigration arrests and detention in Oregon in an effort to meet enforcement quotas. Every day, Oregonians are being arrested, detained, and rapidly transferred away from their families and communities. In this process, the government is denying them access to counsel before removing them from Oregon, and that is where this case comes in. Today's hearing affirmed the impact of defendants' unlawful actions. Plaintiffs' witnesses provided powerful and courageous testimony about the impact of defendants' surging enforcement actions, and I'm joined by a few of our plaintiffs and witnesses here today. Individual plaintiff Leon X also testified to his own fear that the government will detain him and seek to deport him without access to counsel, despite having two forms of deferred action status, having immigration counsel already, and having built a life for himself in the United States since he first arrived at the age of 6. Despite the government's surge in enforcement, ICE, CBP, and DHS have not taken steps to ensure access to counsel at the Oregon field offices. To the contrary, the court received testimony today that access is becoming more and more limited. Whether they are represented already or seeking representation, individuals detained by defendants at the Oregon field offices are effectively denied access to counsel, in the government's own words, unless the government deems it, quote, feasible. And the reality is that the government rarely deems it feasible because they are incentivized to transport individuals away from the field offices rapidly without consideration of their requests for local attorneys or even existing attorney-client relationships. Without access to counsel, what happens at these Oregon facilities before transfer can result in irreversible consequences. Individuals are being deprived of their liberty and often being coerced and incentivized to waive important rights. Every day, community members are being swept away and detained for significant periods of time, or even deported before they have an opportunity sometimes to even speak with counsel. And for individuals who waive their rights under pressure, they cannot take those decisions back. So today, the court heard plaintiffs' witnesses, received our 49 exhibits into evidence, and took our oral arguments and written briefing into consideration. The court now has the case under advisement, which means that we wait to hear the court's decision. And we hope for a swift and decisive order requiring the government to provide the time, space, and notice necessary to uphold the constitutional right to meaningful access to counsel.
Thank you, Tess. Before we open it up for questions, I want to ask some of our plaintiffs who testified in court today if you could briefly tell us what it meant to be a part of this case. And I'll pass it over to Lainey Tupper to start.
Thanks, Isa. We at the Clear Clinic were proud to be in court today defending the constitutional rights and the rights to due process of our fellow community members and neighbors in Oregon today. Part of this lawsuit is about obtaining access to counsel, obtaining access to our clients. And this lawsuit is also about holding ICE accountable for its own actions through the legal system. We're attempting to ensure that every individual who is detained by ICE has access to due process, that they're not able to be detained without having the opportunity to speak to a lawyer to determine whether their detention is legal in the first place, and to obtain due process to potentially challenge their detention and request any relief from removal. And today we saw that due process in action. And we're also honored to be able to take part in this lawsuit hand in hand with our community members like Piccoon and organizations that represent our community members like Piccoon, to ensure that ICE knows that they cannot operate in the shadows, that the community is watching, and that if they deny people's legal rights, there are people who will challenge that.
Thank you so much, Lainey. Katrina, if you could share a little bit about what it's meant to be a part of this.
Yeah, thank you. Well, I'm grateful first for the media coverage of this issue. I know that our community is watching, and this case is for our community, is for Oregonians to have their right to due process, which everybody is entitled to, especially at ICE field offices, a moment of such precarity where decisions that happen there make all the difference of whether that person is going to be able to come home to their family, is going to be able to show up for work the next day, is potentially going to be returned to a country where their life is in significant danger. And for me as an immigration attorney, it has been really wonderful to be able to contribute to this effort with the plaintiffs, and to be able to share the stories from Lane County of what has happened to community members here who have been asking for attorneys and not been given their right to access counsel when they've been detained at the ICE field office or detained in the community. And to have the judge assess, well, we have an executive branch that's exerting a lot of power that has immense consequences for the lives of those both involved in the process, but also for the entire community, for the ripple effect in our schools, in our economy, just our sense of well-being as residents in the state of Oregon. And, we in Oregon have wonderful advocates in Congress who are also doing what they can in this moment. But now it's time for the court to play their part, right, in the three branches of government and the checks and balances that we've all learned about in school. And I'm happy that our community can see that the process is working, that we're bringing this to the attention of the judicial system, that the judicial system is going to take the testimony of community members into account and look at the laws and assess whether what's currently happening on the ground conforms to the Constitution or not. And I look forward to seeing the outcome. Yeah. Thank you.
Thank you, Katrina. Next, I'll pass it over to Marlena from Picun. If you could briefly tell us about what it's meant to be a part of this lawsuit.
Thank you, Isa. Well, to me, it meant it's very important for Pekun to stand behind the right to due process because our community is facing unjust deportations, and they're not getting the opportunity to access an attorney to be able to be um, defended and just the right to cancel. It's a human right. So testifying today meant bringing voices of migrant farm worker families into a courtroom that often excludes them. It meant naming the reality that many people arrested by ICE do not have access to a legal counsel and are being denied meaningful chance to defend themselves.
Thank you so much to everyone for sharing. Now we will open it up for questions if folks have them. You can either put them in the chat or use the raise hand function. Christina.
Yeah, sorry, it's a little loud here. Thanks for taking questions. So, one of the things that the defendant is arguing is that the reason why this is happening is in Oregon is because we only have field offices, so they're only allowed to keep people for 12 hours, and they're claiming that's why they're not able to give people access. Do you know if this is happening in places that have longer detention times?
So I'm happy to answer that. So yes, there are access to counsel challenges at sites across the country right now, and indeed a number of them are cited in this case. There are a number of cases going on right now in which courts have found unlawful deprivation of access to counsel at these facilities where individuals are supposed to be held on a temporary basis. Now, in their briefing, the government actually points to these cases and says, well, these are short-term facilities where individuals are spending a long time. We don't want to do that in Oregon. And they set up this false choice as if the only choice before the court is either rapidly rush people out of Oregon or hold them in inhumane conditions. And that is just not the actual choice here. What we are asking for is for individuals to get meaningful access to counsel, which we've defined for the court as a meeting of an hour. And defendants admit that many people are already at the field offices for several hours. So there's no reason they should not be able to, as they surge enforcement, also appropriately adjust their operations to ensure that the constitutional right to due process is not violated at these sites, where again, important, significant, and irreversible decisions are being made for individuals' lives and liberty.
I would just like, sorry. I'd just like to add, if I could, that a lot of the forms of requested relief that we've made through this lawsuit don't require any additional time whatsoever. So, for example, the opportunity to meet with our clients and prospective clients confidentially in a private setting that's regularly not provided to us. The opportunity to have interpreters if clients and prospective clients don't speak Spanish or English, or if our attorneys happen to not speak Spanish fluently. We've also provided the option for us to provide group or legal orientations so that we can reach more people in a shorter amount of time. And another request that we've asked for that doesn't take any additional time is getting the appropriate documentation from the ICE agents surrounding the reason for detention and the circumstances surrounding detention and arrest. And none of those require additional time. So none of those really implicate the 12-hour restriction on holding people in organized facilities.
Thank you. Ezra?
Hi, yeah. I just wanted to start with a pretty basic question, just so that we can get it kind of in your all's words. Are people detained by ICE constitutionally entitled to representation or access to counsel?
Absolutely.
And can you just elaborate why that is? Because I think for a lot of my viewers, a lot of folks that are watching, they associate the right to an attorney as if you're arrested and you can't afford an attorney, one will be appointed for you. But I understand this is different, and I would appreciate if you could clarify how this is different.
Yes, I'm happy to do that unless Lainey, I don't know if you want to speak to that. So there's absolutely this idea in our country that, yeah, there's this right to an attorney, and if you can't afford one, one will be appointed for you. That's in the criminal context. In immigration, even though the stakes are huge, deprivations of liberty, you're being locked up, you're being sent around the country, you might be sent out of the country, there is no right to an attorney paid by the government. However, there is a right to access an attorney of your choice at no expense to the government. So there's absolutely, in the immigration laws, there are many provisions that enshrine access to counsel at various stages. But importantly, what we are arguing about here today doesn't even rely solely on those specific immigration laws. It really goes to the right to due process in the Fifth Amendment of the US Constitution, and also the First Amendment, the right to protected speech. And communication between attorneys and clients is protected speech under the First Amendment. And so these are constitutional rights that apply to everyone in this country, irrespective of immigration status. Now, how these constitutional rights play out are going to depend, right, on the particular circumstance. And so, what is significant here is that because it is a moment when individuals are facing serious decisions about their liberty and about their rights to remain in their home, to stay in this country, they need to have that protection of an attorney at that moment. And so there's a particular constitutional analysis that comes into play there. And so that is what is really significant here. You have attorneys who are literally at the doors of these field offices offering free legal services at no cost to the government. You have people inside who are asking for those attorneys, and literally one of the Clear Clinic attorneys today, Ms. Moberg, spoke about how she was there trying to reach a client who was taken out the back door. That's the kind of denial of access to counsel that we're seeing, and that is a violation of individuals' constitutional rights.
And then one follow-up kind of on that same vein, and just playing a little devil's advocate, but why should ICE or immigration authorities do anything to facilitate your access to clients in their custody?
Because they have no discretion to carry out immigration enforcement that is in violation of law. And so while they have vast discretion to make detention decisions lawfully, to make transfer decisions lawfully, we're not contesting that. They may not carry out immigration enforcement operations in violation of individuals' constitutional rights. All of the laws have to be followed here. And so that is what we're asking in this case.
I guess they would say that what they're carrying out is not in violation of law. I guess how do you square that, those two, the two opposing perspectives on what their actions are?
Well, I would say that we look to, the court has asked for evidence because actually in an earlier stage of this case, the court pointed exactly to that. The court said, okay, you're telling me these violations are happening. The government's telling me they're not. I need more evidence. So that's what we've given the court. We submitted 49 exhibits today. We had 4 witnesses testify. The government has submitted 4 declarations. None of their witnesses testified today. The court's heard all of this, taken it under advisement, and we believe that the weight of the evidence clearly supports what plaintiffs say is happening, which is that there are violations of due process rights at these sites of detention.
And if I could just jump in
You.
on the point really quickly too, sorry, is like, as we're taught in school, like there is the Constitution, it's this foundational document that lays out the rights that each and every one of us have. And it's very clear that those rights apply. Like there's no question the Constitution applies to everyone in the United States. Like you can't, that's not debatable, but there's just no question. That's what the document says, right? And then you have the executive, the legislative branch, and the judicial branch. And the legislature cannot enact and create laws that violate the Constitution. The executive cannot engage in actions that violate the Constitution, and the judicial branch is responsible for interpreting the laws and making sure that the branches are not violating the Constitution. So that's the overarching document we have, right? To guarantee freedom and liberty for all of us. And so when the government, the executive says, this doesn't violate the Constitution, and a citizen, a person, a human being living in the United States saying, yes, it does, the court comes in to arbitrate that, right? So that's the process that we're in right now. So the government might say, we're not violating the law, but there is a law that they have to comply with, and that is the Constitution. No one is above the Constitution. The president is not above the Constitution.
Thank you. We're going to move on to the next question. Mia?
Hi, all. It's Mia with the Oregon Capital Chronicle. Can you share a little bit more about the declarations that you guys have submitted by immigration lawyers who didn't testify today? Today, we heard two experiences from Ms. Kilgren and Ms. Moberg, but I'm curious how many other immigration lawyers across Oregon are experiencing these barriers to accessing their clients? Can you speak to that a little bit more?
I think the quick answer is many. I need to actually look and see how many of our declarations are submitted from attorneys, but these are absolutely widespread. The kind of we have a number of attorneys who are not part of Clear Clinic, but who also have experience in their varying professional capacities, experiencing the exact same type of access denials that the court heard about in court today. So.
And I would add that my declaration as the executive director of the Clear Clinic is meant to synthesize and summarize the experiences of about 6 of our attorneys who have all been systematically denied access to clients and prospective clients at the ICE field office on McAdam here in Portland, as well as in Tacoma and elsewhere throughout the country.
Thank you. And I have to ask to the immigration lawyers today here, do your clients, are the clients that you're representing, do most of them have a criminal background, or is that not the case?
I'm happy to chime in here. It's not the case. And if you look at the deportation data that we're seeing from the last several months, the portion of people who are being detained who have a criminal background is actually, the pie is getting smaller and smaller in favor of the majority being individuals who have no prior criminal record. And the cases that I've seen in Eugene, individuals are being arrested who have zero, like absolutely zero, like not even traffic tickets, much less criminal arrests. So it's something that I can say really confidently that the majority of the people do not have criminal arrests, at least that have been arrested in Lane County.
Thank you. We're going to move on to the next question, Jamie.
Yes, hi, Madame here. I had a process question about implementation. So, should the judge grant an injunction, is your understanding that the definitions or guidelines put forward about what meaningful access means, for example, an hour-long meeting, that those would be that would be put in place? Or is the expectation or anticipation that the judge would come up with or set forth some kind of definitions for what meaningful access means that might differ from what you put forward in your motion? And related to that, if the judge were to grant an injunction, how soon or how quickly might it actually take effect?
These are great questions. To the first question, we have outlined an injunction that we have asked for that we believe would ensure meaningful access to counsel around the parameters of the time, the space, and the notice that are required to provide meaningful access to counsel in this context. With that said, the court absolutely has broad powers to decide what is appropriate in the case. So that so the court could absolutely grant an injunction that looks different from the exact request that we made. In terms of when it would go into effect, that entirely depends on the order. I think last time we argued our first motion and received an order from the court a little under a week later. We don't know when to expect the court's order this time.
Thank you. Christina?
Sorry, trying to get to the unmute button. The lawyer for the defendants has claimed that they are under threat. They have had buildings burnt. They have had officers attacked and doxxed. Would you agree with those statements? And, obviously they're also claiming that this is part of the reason why they've upped security and why your access looks different. How would you respond to that?
I would respond to that by saying that this is a case about due process, that every individual requires due process at this critical stage when rights and liberties are being decided, and that it is the government's obligation under the law to ensure that access to counsel happens. And if the government makes the decision, as they have, to significantly surge immigration arrests and detentions, they may not do so under the law without ensuring that due process is also observed.
Would you agree, I guess, the first part of the question, that they have been under attack and that it may be more difficult to provide security and access the same way?
I'd be happy to respond to that from our perspective at the Clear Clinic. I checked with our attorneys just last night in preparation for the hearing today, and every single one of our attorneys that has done rapid response, as well as paralegals and other advocates at our office, not any one of those people, and that was, I think, 8 or 9 people, plus myself. None of us have ever seen any action occur at the McAdam Ice Field office that would put any ICE agent in danger. We've never seen any of the types of activities or incidents that they mention in their various briefings. We've never seen anyone block a car. We've never seen anyone intimidate an ICE agent. Nothing like that.
And I would just like to, on this particular topic, there is a particular case within this district court that particularly addresses that, and that is the Oregon v. Trump case that was before Judge Immergut, that granted a preliminary injunction against deployment of the National Guard, in case you need further information.
Thank you. Ezra, and then Troy, and then we will wrap this up. Thank you all.
Sounds good. I wanted to just see, and I don't know if there's anybody else who'd be in the best position to do it, but I think it was Ms. Moberg who testified today about some of the specifics around the challenges of accessing clients. I know that this was already discussed in court, but as a TV journalist and not being able to record anything from court, if you wouldn't mind even just concisely kind of reiterating some of the specific challenges that you all have had, specifically at the Portland field office, with accessing clients there.
Absolutely. There are new alleged problems preventing my access each time it feels like that I attempt to meet with a client at the McAdam office, whether the officer tells me that my client is being uncooperative without providing any further details as to what that means or why that's preventing access from his lawyer, or they say my client has refused the visit with their lawyer. And then I later learned that that is false and that, in fact, my client had been requesting to meet with me. Or they say that due to processing times, I would have to come back in several hours. It's always kind of a new reason why I'm not able to, within a reasonable amount of time, meet with my clients, and sometimes, actually, most often, never actually able to sit down and meet with my clients. I think I think providing access to somebody's counsel when they are being detained and sent out of state hours away from anyone that they know, I think ensuring that they have their attorney at least able to meet with them for a brief 1 hour visit is the absolute minimum that we should be expected to be providing to these individuals, these residents, these community members, in the face of what they're going through.
And in your declaration, you talked about specific instances where vans were observed leaving. Can you just give me a brief kind of rundown of kind of those specific examples?
Yeah, absolutely. My first ever time reporting to the McAdam office to do a rapid response initial consultation with a prospective client was on July 30th. And I waited for a total of just about over an hour. I had gone to request confirmation that my clients were not being transported during that hour. And then at the end of the hour was told that they had already been transported while I had been waiting for them in the lobby.
Thank you. Troy, passing to you.
All right. Y'all's closing arguments specifically highlighted people being transferred to Louisiana or Texas. I'm wondering why you highlighted those two states specifically, as opposed to any other states that are halfway across the country. Are we seeing more of y'all's clients being transferred there recently? Do facilities there present a greater concern for detainees or for you as attorneys?
I'll speak to that just briefly, and then if anybody else has anything to add. I mentioned Louisiana and Texas specifically because that's the most common states that I've personally experienced my clients being transported to from Tacoma. Why they're choosing those particular conservative jurisdictions to send folks to. I can't speak to their motivations, but I will say for sure that the ability for me to access them in those two states' facilities specifically has been extremely difficult. I've had many video appointments scheduled as their attorney that then get canceled at the last minute, and it's difficult to be trying to track people as they keep moving them without notice to their attorney who's trying desperately to get into contact with them.
I would add that we've had clients transferred also to Arizona and Mississippi. And Louisiana and Texas were just the ones that Miss Moberg's clients specifically have been transferred to, but we have seen a lot of clients transferred to Texas in particular. And like Miss Moberg highlighted, each and every facility that people get transferred to presents different issues with obtaining access and presents new systems and processes that we all have to learn. So it just transfer around the country makes it incredibly difficult to access our clients. And also the online detainee locator system often doesn't even tell where our clients have been transferred within. Sometimes we've had more than 2 weeks where we can't identify clients after they've been identify where they've been taken after they've been transferred out of Oregon using the online detainee locator system. So the transfers around the country just present myriad challenges to us in obtaining access to our clients. Sometimes which we're never able to make that connection, and they get our clients will be deported in the meantime.
Thank you all so much. Marlena, I wanted to see if you wanted to maybe chime in about what other actions Pikun has going on today, and then we can close today.
Of course. So today is the first day of our we have a series of actions, and it's a campaign that we started, a day without an immigrant. So today, um, our action is happening in Woodburn and in Salem, and I believe there's Hood River and just other places that are gathering in solidarity. So the people that are able to show up for those who can't speak up do and make their presence stronger by speaking on behalf of our migrant communities, the communities that are being terrorized and scared by ICE. And that's where most of our organizations should be today, where a day without an immigrant is happening. And we have many businesses that are also being solidary with our action today. So yeah.
Thank you. Well, with that, that concludes our media availability. Thank you all so much for joining. And I hope you all have a great rest of your day.